Hello friends, this is Hatim Rampurawala, and in this video we would be revising section 70 of the CGST Act. Okay, so section 70 is in relation to power to summon person to give the evidence and produce the documents. So we are giving summon basically to a person for what reason? That is that to give the evidences and to produce and requiring that person to produce the documents and to give the evidences. Okay, so we'll quickly go through the entire section. During the course of the inquiry under these acts, so during the course of the inquiry under these act, the proper officer may summon any person to appear before him and give the evidences or produce the documents. The person to whom such summon has been issued is duty bound. See, in course of any proceedings, inquiry under these act, the proper officer may issue a summon to a person. So if a summon has been issued, the person on whom such summon has been issued is duty bound to appear before the officer and bound to tender the evidence, and bound to tender, that is to submit the evidence which has been asked for. If he is also bound to produce all the documents which were required to be furnished, he is also bound to produce those all documents which were required to be furnished. Responsibility of the person so summoned: the person who is issued summoned is legally bound to attend either in person or by an, it is not BYAN entire word, but by an authorized person. So person who is issued summon is legally bound to attend there in person. So he is legally bound to attend there in person by an or by an authorized person, and he is bound to state the truth before the officer who has issued the summon upon any subject which is the subject matter of the examination, and to produce such documents and the things as may be required. Then consequences of the consequences of non appearance to the summon. So if a person to whom the summon has been issued does not issue, so what are the consequences? The various section has been given under which he will be liable, that person will be liable, and he will be liable to a penalty of 25,000 as well under section 122 subsection 3D of the act. We'll quickly read the entire para. The proceedings before the official who has been issued the summon is deemed to be judicial proceeding. Basically this proceedings under which summon has been issued is known as judicial proceeding. If a person does not appear on the date when summoned without any reasonable justification, he can be prosecuted. See, the word they have given is the person can be prosecuted under the section 174 of the Indian Penal Code if he abscond to avoid services of the summon, or avoid service of the summon, that is he is absconding, that is he should not receive the summon only. He can be prosecuted under section 172 of the IPC, and in case of he does not produce the documents or the electronic records required to be produced, he can be prosecuted under 75. So if he is not appearing, so 174. If he is absconding to avoid service of the summon, 172 of the IPC. And if he is not producing the documents, electronic records required to be produced, he can be prosecuted under section 175. In case he gives false evidence, he can be prosecuted under section, he can be, see what they are given is, he can be prosecuted under section 100. Wait a second. If he don't produce, then 175, prosecuted under 175. If he gives the false evidence, if he produce but if he gives the false evidence, he can be prosecuted under 193 of the IPC. In addition, if a person does not appear before a CGST SGST who has been issued the summon, he shall be liable to a penalty of so if he does not appear, so he will be prosecuted under 174 as they were given in first in the third line, second and third line of the para, and he will also be liable to a penalty of 25,000 rupees under section 122 subsection 3 clause D of the act. So we're done with this. So basically, when a summon has been issued, in short, the person is liable to appear before the officer, CGST SGST officer, and is required, his duty bound to produce the documents, produce the evidence which has been asked for in the summon. Guidelines for the issue of the summon: CBIC in the Department of the Revenue, Ministry of the Finance, has issued the guidelines from time to time to ensure that the summon provision are not misused in the field. Some of the important highlights of these guidelines are given below. So guidelines for issue of the summon, which have been issued from time to time to ensure the summon provisions are not misused. So what all are the guidelines from the CBIC? First, summon are to be issued as a last resort where the assessee are not cooperating, and these section should not be used for the top management. So 2 points have been given, that it should be used as a last resort where assessee is not cooperating, and it should be not used for the top management. Second, the language of the summon should not be harsh and legal, which cause unnecessary mental stress and embarrassment. Sorry, not embarrassment. Yeah, it is embarrassment, sorry. And embarrassment to the receiver. Then summon by the superintendent, summon by the superintendent should be issued after obtaining prior, it is written in much small letters, so it is visibility is little hard. But though I can see it's not that difficult or not that hard. Sorry, we'll continue. Summon by a superintendent should be issued after obtaining the prior approval. See, if the superintendent is issuing the summon, then it should be issued after obtaining the prior written permission from the officer not below the rank of the assistant commissioner, with the reasons for issuance of the summon to be recorded in writing. See, he should take the prior permission from the assistant officer not below the rank of assistant commissioner with the reasons of issuance. See, he should state the reasons as well to the assistant commissioner. That is for what reason he is issuing the summon, for what reason the person officer is issuing the summon, to be recorded in writing. Okay, and that should be recorded in writing. So basically what it has been given, that before the superintendent issues the summon, it should take a written permission. See, in fourth point they will give a relaxation as well, but in third point they are given is written permission should be taken from the assistant commissioner not below the rank of assistant commissioner, and for reasons to be recorded in writing. Reasons for the issuance of the summon to be recorded in writing. Then in fourth point, where for the operational reason it is not possible to obtain the prior written permission, then oral telephonic permission from such an officer must be obtained. Oral or the telephonic permission must be obtained, and the same should be reduced to writing and intimated to the officer, and then it should be reduced in writing, that it should be done in written as well. Permission should be taken in written and intimated to the officer according such permission at the earliest opportunity. So after obtaining an oral or telephonic, this written permission should be obtained as early as possible. Then fifth point, in all the cases where the summon is issued, the officer issuing the summon should submit a report or should record a brief of the proceedings in the case file and submit the same to the officer who had authorized the issuance of the summon. So in all the cases, the summon where the summon is issued, see, if the summon has been issued to a person, then the officer issuing the summon should submit a report. See, summon has been issued, the person has been came, and see, the proceedings has been done, he has obtained the evidences and the documents which has been asked for, and he should prepare the report basically after that summon has been done, and submit it to the, and should record a brief of the proceedings which all has been done, a brief of the proceedings, and submit a report in the case file and submit the same to the officer who has authorized the issuance of the summon. So the one officer who has authorized the issuance of the summon to the other officer, after the summon has been done, he should submit the report, and he should submit a report basically, and should record the brief of the proceeding, what all has been done in the brief, or that is the brief of entire proceedings in a case file, and submit a report to the person who has authorized the offense of the summon. So we'll quickly read this 5 point again, understand this 5 point again, that is the guidelines for the issue of the summon. First, summon should be the last resort where the assessee is not cooperating, it should not be issued to the top management. Then the language should not be harsh and legal, which unnecessarily cause mental stress and embarrassment. And if superintendent is issuing the summon, he should take permission of the AO, that is not take the permission of the officer not below the rank of assistant commissioner in writing, and if it is not possible in writing, he should take in oral or telephonic permission, but after that it should be recorded in writing, and accordingly accord such permission at the earliest opportunity. Then after the summon thing has been done, he should submit a report and the brief summary or a brief of the proceedings in the case file to the person who is authorized. Then the senior management official such as CEO, CFO, the senior management of the company, basically the CEO, CFO, general manager of the large company and the public sector undertaking, should not generally issue the summon for the first instance. They should be summoned only when there is an indication of the investigation, when there is an indication in the investigation of their involvement. So if there is any indication of their involvement, then only the summon can be issued to them, of the involvement of the in the investigation, of their involvement in the decision making process which led to the loss of the revenue, which led to the loss. If there has been their hand, if the decision making thing has been involved and it has been found indicated in the investigation, then only the summon can be issued to them. Then the this point has been done. Then the general guidelines: prosecution to be observed while not prosecution, what I'm reading, man. Precautions to be observed while issuing the summon. So what all precautions should be should an officer should take while issuing the summon? Okay, there are 4 points in this, and then the section is over. That is, it has been complete. That is, the following precautions should be generally be observed while issuing when summoning a person. First precaution: the summon should not be issued for the appearance where it is not justified. So unnecessary, if it is not justified, the summon cannot be issued. That just come and meet and give the document thing and to produce the evidence. So not again and again we can call a person for such a producing of any documents. So until and unless there is any justified reason, summon cannot be issued. A power of the summon can be exercised only when there is any inquiry being undertaken and the attendance of such a person is considered necessary. Only when there has been an inquiry being undertaken and attendance of such person, for instance a person A, his attendance is necessary, then only he should be called, he or she should be called upon, not only he. Sorry, we'll move again to the point. Then what has been given, wait a second, yeah. What precautions should be taken? So basically, first was a summon should not be issued for the appearance if it is not justified, and the power to issue summon can be exercised only when the inquiry is been undertaken and the attendance of such a person is considered necessary. Second, normally summon should not be issued repeatedly. As far as practicable, the statement of the accused or witnesses should be recorded in a minimum number of appearance. So minimum, this means that in minimum number of appearance, that is if it has been called once, at that point the entire questioning should be done. It should not be like today I will ask 3 questions and come on next day again and answer 2 questions and then come on the third day and answer 1 question. It's not the case. Ask all the question, a proper question should be prepared, and the entire thing, asking of any documents or producing of any asking for producing the evidence should be done at once. Then respect the time of the appearance given in the summon. Respect the time of the appearance. No person should be made to wait. No person should be wait for the long hours before their statement is recorded. That we will call in come in 9 in the morning, and their summon is being done on at 3 p.m. basically after 6 hours. So no person should be made to wait for the long hours before their statement is recorded, except when it has been decided very consciously as a matter of a strategy. Only if it is considered as a matter of strategy, then only it should be done. This thing should be done, and preferably statement should be recorded during the office hours. However, an exception could be made regarding the time and the place of recording. See, it should be done on during the office hour only, but exception can be made just regarding the time. That is, what office hour? For instance, an office hour is from 10 to 6. So exception can be made regarding at different time. For instance, on first day they have been called from 10 to 1. For 10 to 1, not ending time has not been prescribed, but 10, and next day they have been called at 3 p.m. See, this timing can be differ, but that has to be between the officer only and the place of the recording statement having regards to the fact in the case. So if we summarize this thing, precautions. So first is it should be issued only if the reasons are justified. Then power to issue summon should be done only if there is an inquiry being undertaken and the attendance of such person is necessary. Then summon should not be issued repeatedly. That is, as far as practicable, the statement of the accused should be accused or the witness witnesses should be recorded in the minimum number of appearance. Then in respect of the time of appearance in the given of this summon, no person should be made to wait for the long hours before the statement has been recorded, unless such when except when it has been decided as a very concisely or very consciously as a matter of the strategy. And fourth is preferably statement should be recorded. Preferably statement should be recorded in the officer. However, an exception could be made regarding the time and the place of recording the statement. Time and the place of recording the statement having regards to the fact in the case. So we are done with this section 71. Section 70. Thank you for watching the video.